Welcome to This Explainer. Today, we're unpacking a truly gripping legal and medical drama that actually made its way all the way to the Supreme Court of the Philippines. We're looking at the case of Rudy Ampolito versus Top Ever Marine Management. Really, it's a story about a seafarer's desperate fight for his health, a massive battle against corporate loopholes, and a profound look at how the highest court interprets the law to protect workers out on the high seas. I want you to put yourself in our protagonist's shoes for just a second. Imagine you're miles away from home, working a grueling, physically demanding job on a cargo ship, and you suddenly fall mysteriously ill. I mean, your body is literally failing you. But then, months later, your employer's doctors look at you and say, hey, you're perfectly fine, go back to work. How on earth do you prove them wrong? And more importantly, how do you survive the legal gauntlet to get the compensation you actually deserve? All right, let's dive right into this. We're going to break this whole story down into 6 parts. Sickness on the high seas, the medical mystery, the legal ping pong, the Supreme Court steps in, the 120-day rule flaw, and finally, the concurring twist. Starting with part 1, sickness on the high seas, a sudden illness on the MV Coral Opal. To really understand the human stakes here, we have to meet Rudy Ampolito. Rudy was an able-bodied seaman, and just to be clear, this is definitely not a desk job. An able-bodied seaman is out there overhauling gears, chipping away rust, and painting the deck of massive cargo ships. Rudy was incredibly loyal, too. He had been continuously rehired by his employer for 6 solid years, just bouncing from contract to contract, ship to ship. But then, in October 2015, just 2 months into his latest deployment on a vessel called the MV Coral Opal, things took a really terrifying turn. Out of nowhere, he started experiencing severe dizziness, extreme weakness, blurred vision, and these mysterious bruises all over his body. He was entirely unfit to work and literally had to be medically repatriated back to the Philippines. That brings us to part 2, the medical mystery, uncovering the diagnosis. So when Rudy gets back to Manila, he's immediately admitted to the hospital, and a hematology team starts trying to figure out what exactly is destroying his blood. After a bunch of bone marrow biopsies and cytogenetic tests, they finally find the culprit. It's myelodysplastic syndrome, or MDS. Essentially, MDS is a bone marrow failure disorder where your body just stops producing enough healthy blood cells. So we're talking red cells, white cells, and platelets. It's an absolutely severe condition. But what's really crucial to understand here is that medical literature strongly links MDS to environmental and occupational exposures, specifically to chemicals like benzene, which is found in industrial paints and solvents. You know, the exact same paints and solvents Rudy was handling day in and day out for 6 years. Now, Rudy underwent treatment for several months, but then, in May 2016, his treatment was just abruptly discontinued. The company-designated physician claimed Rudy's blood count was completely normal and verbally declared him fit to work. But if we look at his CBC test results from January all the way to May 2016, they reveal a glaring contradiction. The normal reference value for platelets is somewhere between 144,000 and 372,000. Rudy was hovering right around 50,000. He was nowhere near normal. He was suffering from severe thrombocytopenia, which is a hallmark symptom of MDS. Yet the company was basically trying to wash their hands of him. Moving on to part 3, the legal ping pong, the battle in the lower courts. Knowing he was still severely sick and completely unable to work, Rudy filed a complaint for permanent total disability benefits, and this sets off an incredibly emotional legal roller coaster. At the very first level, the labor arbiter actually ruled in Rudy's favor. They agreed that his 6 years of continuous exposure to harmful chemicals on those ships caused his illness. But then the employer appealed, and the National Labor Relations Commission and later the Court of Appeals entirely reversed that decision. They sided with the employer. Their reasoning? Well, they argued that MDS isn't officially listed as an occupational disease. And since Rudy was only on this specific ship, the Coral Opal, for 2 months before getting sick, he couldn't prove a direct causal connection during that short contract. You see, the lower courts used a very, very strict interpretation of his employment contract. They pointed directly to Section 32A of the Standard Seafarer Contract, which lists 4 rigid conditions that absolutely must be met to prove an occupational disease is compensable. The courts essentially said, look, Rudy, you didn't prove that just 2 months of work directly caused this massive bone marrow failure. They treated his 6 years of prior service as legally irrelevant. As you can imagine, this was a massive, seemingly insurmountable roadblock for him. But now we get to part 4. The Supreme Court steps in, the highest court's ruling. Rudy refused to give up, and he elevated his fight to the highest level possible. The Supreme Court looked at the exact same facts and completely reversed the Court of Appeals, ruling squarely in favor of Rudy. They applied something known as the reasonable linkage standard. The court basically said, hey, you can't just look at his last 2-month contract in a vacuum. Rudy was continuously rehired for 6 years, doing the exact same job, handling the exact same industrial solvents, cleaning agents, and paints that contain benzene. The court ruled that in cases like this, you don't need to prove ultimate, absolute certainty. You only need reasonable probability, and it was highly probable that 6 straight years of chemical exposure contributed to his bone marrow failure.
And that brings us to Part 5, the 12-day rule flaw, the fatal technicality.
So, the Supreme Court didn't just rule on the medical science. They also caught a massive procedural blunder. In Philippine maritime labor law, there's a very strict timeline known as the Elberg Ship Management Rule. When a medically repatriated seafarer reports to the company doctor on day 1, a literal clock starts ticking. The doctor has exactly 120 days to issue a final definitive medical assessment on whether the seafarer is fit to work or permanently disabled. Now, if further treatment is justified, this can be extended, but only to an absolute maximum of 240 days. The crucial takeaway here is this. If a company doctor fails to issue a conclusive assessment within this strict window, the law steps in and automatically declares the seafarer totally and permanently disabled. And here is exactly where the employer made a fatal legal error. The company claimed they had a medical report dated January 2016 declaring Rudy fit to work, but they never actually gave a copy of this report to Rudy. The Supreme Court was crystal clear on this. A doctor cannot just issue a report and keep it locked away in a filing cabinet somewhere. They must actually furnish or hand the assessment to the seafarer so the seafarer understands their own diagnosis and has a fair chance to contest it. Because Rudy was never given the assessment within the 120 or 240-day window, he was deprived of due process. Therefore, by operation of law, his disability became permanent and total. The result? The Supreme Court ordered the employer to pay Rudy Ampolitod his full, total, and permanent disability benefits. That amounts to $60,000. Plus, because he was forced to litigate for years just to protect his rights, the court awarded an additional 10%, or $6,000, in attorney's fees. So after years of severe illness and endless legal ping-pong, it was a concrete, absolute victory for the seafarer. Finally, let's look at Part 6, the concurring twist, Justice Kagua's perspective. Now, you might think the story ends there, but there is an incredible footnote to this case. When the Supreme Court issues a decision, individual justices can actually write separate opinions. Justice Alfredo Benjamin Kaguwa wrote a concurring opinion. He agreed 100% that Rudy should get his $60,000, but he completely disagreed with how the majority of the court got there. He argued that the court shouldn't have spent all that time trying to prove reasonable linkage to benzene exposure using internet medical articles. Why? Because legally, they shouldn't have had to. Justice Kaguwa pointed to a specific legal precedent that completely flips the script on the burden of proof. Because Rudy's illness manifested during the term of his employment contract, the law states it is disputably presumed to be work-related. Justice Kaguwa argued that this presumption must automatically mean it is compensatable. The burden shouldn't be on the sick, dying seafarer to prove that paint fumes caused his bone marrow failure. The burden should be entirely on the multi-million-dollar shipping company to prove that the job didn't cause it. And since the employer failed to prove that, Rudy wins by default. It's a fascinating legal nuance, isn't it? It really highlights the massive power imbalance in labor disputes. And it leaves us with a vital question to ponder. When an employee falls sick and the employer controls the doctors, the medical records, and the timelines, shouldn't the presumption of work-relatedness always legally favor the employee? Think about how that simple shift in the burden of proof completely changes the landscape of workers' rights. Thank you so much for joining this explainer, and we'll see you in the next one.